Hi, my name is Ken Schwartz. I'm an attorney. I have an office in Bethpage, New York. My firm specializes in distressed real estate, defense of foreclosure proceedings, loan modifications, short sales, and anything else relating to distressed real estate, particularly litigation. Anyway, we are here to talk about defenses to a foreclosure action, specifically the defense of legal standing. The first thing you need to know about legal standing is that it has nothing to do with whether you've made a payment or whether you've not made a payment. And a lot of folks, when they look at foreclosure defense, say, gee, I haven't made a payment, so why am I bothering to defend the case? What benefit could I derive from that? And the answer is legal standing, which is a threshold issue in litigation. Legal standing can make all the difference in a case. It can result in dismissal of the case. And the one outstanding factor is it has nothing to do with whether payments are current or not under the mortgage. So let's ask the obvious. What is legal standing? Legal standing means the ability of a lender to bring a lawsuit. The ability of a lender to bring a lawsuit. For example, if you fracture a leg, God forbid, and you want to bring a lawsuit to recover damages because of somebody's negligence, that lawsuit belongs to you. I can't bring that case on your behalf, unless, of course, you sell me the case. You can bring that case because you have legal standing. But a third party like me, I can't bring that case because I don't have legal standing to bring the case. That's one of the simple examples. Now, legal standing in the case of a foreclosure action gets a little bit more involved, as most things in life are. And let's define a few terms first. One is what is a promissory note? What is a mortgage? Well, the mortgage loan, in its simplest terms, consists of A, an IOU, that's a promissory note, and B, a document which ties the note or the IOU into the real estate, the property, and that's called a mortgage. It can get more complicated, and very often it does, and the reason being is that very often mortgages are done in a way that saves mortgage tax, which can be very expensive, depending upon the county that you're in. It can be 1% plus, 1% of the principal amount and up. In the city of New York, it's about 2% of the principal amount and up. So folks will do documents called a consolidation extension modification agreement, and they combine mortgages. And when mortgages are combined in consolidation extension modification agreements, life can get somewhat complicated. And complicated, in the case of foreclosure defense, can be a good thing. So let's talk about we'll talk about that in a few minutes. The other thing I'd like to define for you is in the context of foreclosure proceedings, we see loan servicers and we see investors. What is an investor? Investor is the party that lends the money, that we commonly refer to as a bank. But mortgages get sold all the time. They get transferred all the time because mortgages are sold in the secondary mortgage market from party to party to party. Banks are combined, banks are taken apart, and the mortgages will move from company to company. The party that owns the actual paper, the mortgage loan, that's called the investor. The folks that handle the day-to-day on a mortgage loan, that's called the loan servicer. And we have different rules that apply to loan servicers and to investors. Now, when a lawsuit is brought, generally it's in the name of the investor as the plaintiff. That doesn't have to be the case, because if a power of attorney exists, if a document exists that gives another party like a loan servicer the ability, the right, the authority to bring a lawsuit, then by all means they can do so if they have the authority. More often than not, it's the investor who is the plaintiff in the case. Now, what gives a plaintiff legal standing to bring the case? The promissory note, that's the operative document. Although the law in this area fluttered around at the very beginning of this down cycle in the economy. It's fairly well settled by the New York Court of Appeals, which is the highest appellate court in the state of New York, under what's called the Aurora v. Taylor decision. It's pretty well settled, and it's been settled in the appellate divisions for a few years, that it's the promissory note that makes all the difference when we're talking about legal standing in a foreclosure proceeding. Now, promissory notes are transferred very often from party to party to party. How is a promissory note transferred? Well, a promissory note is a negotiable instrument. What does that mean? It's like a check. You write a check on your checking account. That's a simple form of negotiable instrument. How do you transfer it? You endorse it. That's how you transfer a negotiable instrument. Now, I'm using too many legal terms in one place, and I apologize for that. If it's endorsed pay to the order of, and there's a specified payee, then it's endorsed to the order of a party. And we know the endorsee is the party in interest. What about if it's not endorsed? What about if it's an endorsement in blank? Well, then we have special rules that apply. Let's take the easiest case, if it's order paper. If we have a promissory note that was originally payable to a City Mortgage, and it was endorsed to Wells Fargo, and on the promissory note it says payable to the order of Wells Fargo, and that pretty well establishes standing in the name of Wells Fargo, and we would have difficulty arguing to the contrary. But what about if we have a promissory note that's payable to City Mortgage, endorsed to Wells Fargo, and then City Mortgage brings the case? Does City Mortgage have legal standing to bring the case? The answer is, if they have the original promissory note, that's probably all they would need. Probably. But the facts can vary. What if we have an endorsement in blank? In other words, pay to the order of, and then it was never filled in. Well, in these cases where you don't have order payable to the order of a party on a promissory note, if you don't have an endorsement on what's called an allonge, which is an endorsement on a separate page, if you don't have these things, then you have to show possession of the original note, or the original endorsement. And in the world of allonges, which are endorsements on a separate page, that's a French term that refers to endorsements on a separate page, and the allonges are very often used in the secondary market. In this situation, you have to show possession of the original, and the courts say you need to establish the details as to where the original may exist, who has it. And that becomes a sticky issue sometimes, because loan servicers may say, well, we have the original. Then we ask the question, well, what gave you authority to possess the original on behalf of the lender, the plaintiff in the case? Well, I got a power of attorney. If you have a power of attorney, and it's a valid power of attorney, that's an okay answer, and that can establish legal standing. We have a pooling and servicing agreement. That as well can establish legal standing. Very often, though, the power of attorney may not be valid. Very often, the power of attorney may have expired. Quite often, mistakes are made in powers of attorney. Things like this are defenses to a foreclosure proceeding in terms of the standing defense. If standing doesn't exist in the name of the plaintiff, the action must be dismissed. A few more things you have to know about standing. You must raise the defense, and here we go into legal terminology again, as an affirmative defense as part of an answer that's timely served. If you don't do it as part of an answer, then you need leave of court for the court to give you permission to file a late answer or to amend an answer, and that's not there for the asking. To vacate a default and to file a late answer, you have to show an excuse, a good excuse as to why you didn't do it on time, and merit to the case. Courts are very reluctant in these cases to vacate defaults and allow late service of a pleading. They just are, and I tend to see this in all the counties. However, if you file a timely answer and you raise an affirmative defense as to legal standing, you might very well have a defense in your case that can preclude or prohibit the lender from bringing the foreclosure proceeding unless they are able to cure the infirmity in their case. And legal standing must exist as of the time the case was started. The case is started when the complaint and the summons are filed in the county clerk's office. If legal standing did not exist as of that time, that means legal standing doesn't exist and the case must be dismissed. On the other hand, if legal standing is established, then you must go on to the next step, search for additional defenses. And that's my summary of legal standing and how it may assist you in defending your foreclosure action. I'll see you soon. Bye-bye.